Now into the studio with your host of Law Talk, Attorney Steve Sabra.
Good afternoon, everyone. This is Attorney Steven Sabra. You're listening to Law Talk on 1480 WSAR. We do this show every Tuesday from 1 to 2 p.m. And it's your opportunity to call in with any law-related questions. Our call-in number 508-673-1480. And anything that's on your mind that's law-related is fair game. In the news today, from a legal standpoint, is an interesting case that the U.S. Supreme Court is dealing with, and it kind of applies, well, it certainly applies to a certain extent to what has gone on locally here about posts on Facebook, and dealing with the difference between a crime being committed because it's some type of a threat versus the protections we're all afforded as citizens under the Fourth Amendment. The First Amendment of the Constitution. So the judges, of course, at the U.S. Supreme Court, they don't just pick an issue out of the air in the sense that they don't develop policy. What they do is a case has to come before them. So what was the case that came before them dealing with this issue of, is it free speech or is it some kind of an illegal threat? Well, the case is basically that this is a case out of Pennsylvania. A man was convicted of posting violent threats on Facebook in the form of rap lyrics about killing his estranged wife, shooting up a school, and slitting the throat of an FBI agent. And I'll get you the more specifics about what exactly was said. His lawyers before the U.S. Supreme Court argued that, well, he didn't mean to threaten anybody, that it was under a pseudonym, and it was just a way of him sort of, as the news article said, venting his frustration about splitting up with his wife. The government argued, the government argued as part of their argument that it's not subjective intent. In other words, it's not what the defendant intended himself, but more about what a reasonable person, so that's called an objective standard, whether his words would make a reasonable person feel threatened. And that's the standard that was used in this particular case when this was a federal case, when this federal jury convicted him of threats of violence. So what the judges in the U.S. Supreme Court were dealing with is that standard, this objective standard, reasonable person standard, too broad, and would it end up including language that would be protected under the First Amendment? So probably in this particular case, you're going to feel that, those are threats, and he was convicted rightly. But I think what the judges in the U.S. Supreme Court are dealing with is not just this. They're supposed to deal with just this particular case, but they set precedent, and that's what they want to be careful about. And one of the judges asked, well, how do you prove what's in someone's mind? And of course, the defense lawyer said, well, you look at context, you look at other records, computer, cell phone, that type of thing. And what the defense lawyer said was something to the effect that, well, nowadays you get kids, teenagers that are just putting stuff on Facebook that's, it's not right. It's as the article said, ill-timed, it's sarcastic, and they end up being convicted and possibly end up in jail. And so, the judges ask questions. Some of the judges ask questions at these arguments, and Chief Justice Roberts asked a question about, well, the government could just come up with what a reasonable person familiar with teenagers, and looking at this particular example, do in these video chat rooms. Scalia, who is a very conservative judge, felt that the standard, the reasonable man standard, objective standard was it sounded like he felt it was fine. It really doesn't affect speech. So in the past, the Supreme Court has said that true threats to harm another person are not protected, but you have to distinguish between protected speech, and some of these things might apply to what's going on here in the city of Fall River, because they said specifically protected speech such as political hyperbole or unpleasantly sharp attacks. So that's kind of the dividing line. You know, those things are protected. Political hyperbole and unpleasantly sharp attacks, but real threats are not. And of course, the problem is determining what's a real threat and what isn't. And you know, this, one of the judges, actually the Chief Justice, talked about an Eminem's song that had lyrics like "Dada, make a nice bed for mommy at the bottom of the lake," and whether or not that language in a rap song ought to be prosecuted. And I don't think he thought that way, but that's kind of one of the issues he was trying to distinguish. Maybe the distinction being that it was a part of a song as opposed to some post about, like in this case, where this particular defendant said the following in one of the posts about his wife. There's one way to love you, but 1,000 ways to kill you. I'm not going to rest until your body is a mess, soaked in blood and dying from all the little cuts. This was the quote in the case that this particular defendant said about his wife, and the wife testified at the trial that it made her fear for her life, and that's why she ended up getting protective order. On top of that, this was apparently, I'm not exactly sure why, but it was investigated by the FBI, maybe because it was over the internet, because a female FBI agent went to this person's home to ask him about the postings, and this defendant then, after the FBI agent left, went on Facebook and said, "Little agent lady stood so close, took all the strength I had not to turn," well, he says, "the bitch ghost, pull my knife, flick my wrist, and slit her throat." I mean, these are awful things that he's saying about the FBI agent. I'm not surprised that he was convicted, but the judges have to kind of try to make a distinction between, as they say, political hyperbole, or in this case, maybe unpleasantly sharp attacks. This is going to be a tough case for them to say, I think that this is protected language under the First Amendment, but maybe they'll use this as try to come up with more of a fine line as to what's protected and what isn't, and what can be prosecuted, and what someone could potentially be convicted of threats on Facebook. And I suppose we're going to see more and more of these types of cases dealing with online activity, so to speak. All right, we're just about at the end of our hour here. To reach me at the office, 508-674-0890. Again, 508-674-0890. Mostly what I do is serious personal injury cases, workers' compensation, and criminal defense. We're located in Somerset at 1026 County Street. Every Tuesday I'm here. My name is Attorney Stephen Sabra. You've been listening to Law Talk on 1480 WSAR.